I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco-Fox. Attorney Fox practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is a prenuptial or postnuptial agreement enforceable in Connecticut if it is unfair?
That's a good question, Emily, and we actually get that question fairly often. Inequality or unfairness alone will not render a prenuptial or a postnuptial agreement unenforceable in Connecticut. However, if an agreement is unconscionable, a court can and will determine that all or parts of that agreement are unenforceable. So it's important to recognize the distinction between what is fair and what is unconscionable, or what is unfair and what is unconscionable. Connecticut courts generally recognize the freedom of the parties to contract, and they recognize that the parties are free to contract for perhaps an unequal distribution of assets or a waiver of certain rights, such as a waiver of estates rights, or under certain circumstances, a waiver of alimony rights. However, if these terms that the parties have contracted for would later lead to an unjust outcome for one of the parties, the courts will determine that the agreement is not enforceable. So unconscionability generally means unjust. So a court will determine that an agreement is unconscionable if enforcing the terms of the agreement would create an unjust outcome for one of the parties. And again, there's a distinction here between unfairness, or just an imbalance in the agreement, and an unjust outcome for one of the parties. And those are two very different things under Connecticut law. So in order for a court to determine whether or not an agreement contains provisions that would be unjust, the court will really need to do a case-by-case analysis of the facts and circumstances of each of the specific circumstances surrounding the execution and enforcement of the agreement. And this can vary from case to case. So for example, terms that may be conscionable for some parties may be unconscionable for other parties. So it's also important for the parties to know that their agreement could have been fair and equitable at the time that they entered into it, and still be unconscionable at the time enforcement is sought, or generally at the time of dissolution. So just because you perhaps even had counsel who advised you, yes, this agreement is enforceable, when you were negotiating it and when you executed it, doesn't mean that that agreement will be enforceable at the time of dissolution. So how can this happen? How can you have an agreement that was once enforceable that later becomes unenforceable? It can happen in a number of different ways. The most common way is if the circumstances of the party has changed so significantly and in such a way that the parties couldn't have foreseen, that the court would generally determine that enforcement of those provisions at a later time would lead to some kind of unjust outcome for one of the parties. Now, this generally happens when the financial circumstances of the parties have changed significantly during the marriage. So for example, a party waives alimony and then they later become disabled and they're no longer able to support themselves. This may be a circumstance where the court says to enforce a waiver of alimony would lead to an unjust outcome because this individual doesn't have a means of supporting themselves, and therefore that provision, or perhaps even the whole agreement, would be determined to be unenforceable by a Connecticut court. Additionally, where the marriage is broken down due to the fault of one of the parties and there's been a prenuptial waiver, it is also possible in Connecticut that the court would say that the waiver or other provisions of the agreement are unenforceable. Again, this is a case-by-case inquiry that the court makes. Now, it's also important for parties to understand that postnuptial agreements in Connecticut are reviewed as to enforceability under this heightened or special level of scrutiny. So what does this mean? It means that the court is using a different standard when evaluating prenuptial agreements and postnuptial agreements when determining whether or not they're enforceable. Courts presume that spouses are going to be less cautious with one another when contracting. They may be more trusting of one another, and that may result in one of the spouses getting taken advantage of. So the courts impose this higher level of scrutiny when evaluating a postnuptial agreement to ensure that there hasn't been any situation where one of the spouses was taken advantage of. So What does this mean on a practical level? It means that perhaps you may have terms that are in a prenuptial agreement that a court determines are enforceable or conscionable, but they may be considered unconscionable or unenforceable in a postnuptial agreement. So this isn't necessarily a straightforward area of the law. If you have an agreement, just because you were told that it was enforceable when you'd entered into it, doesn't mean that it's always going to remain enforceable. So it's important not only to consult counsel when drafting and negotiating these agreements, but certainly at the time of dissolution or when enforcement is sought, to ensure that you have an enforceable agreement. And certainly if your financial circumstances or your partner's financial circumstances have changed dramatically since the time that you entered into one of these agreements, it's advisable to consult with an attorney, determine if the agreement is still enforceable, and if not, perhaps modify it in a way that would keep it compliant with the law, or enter into a postnuptial agreement, so that you can ensure that your agreement is always going to be enforceable and that your wishes and your spouse's wishes are effectuated at the time of dissolution or in the event of one of your deaths.